Farmers' Rights IPR. Now we are going to see about this topic. Introduction. Protection of Plant Varieties and Farmers' Rights Act 2001 came into existence to provide an effective system for the protection of farmers' rights and plant varieties. Why it is needed? It is considered necessary to protect and recognize farmers' rights in respect of farmers' contribution made at any time in conserving, improving, and making available plant genetic resources for development of new plant varieties and accelerate agricultural development. Let's see an overview about this. Such protection is likely to facilitate the growth of seed industry, which will ensure the availability of high quality seeds and planting materials to the farmers. The Protection of Plant Varieties and Farmers' Rights Act 2001 defines the farmers as any person who cultivates crops by cultivating the land himself or cultivates crops by directly supervising the cultivation of land through any other person or conserves and preserves severally or jointly with any person. Section 3 of this Act empowers the protection plant varieties and farmers' rights. It has a authority which has the power of civil court for purpose of receiving evidences, enforcing attendance of witness, compelling the discovery and production of documents. Section 11 of the Act empowers production of documents. Section 11 of the Act empowers the authority in this regard. Protection of Plant Varieties and Farmers' Rights Authority. It was established on 11th November 2005 by Department of Agriculture and Cooperation, Ministry of Agriculture. It consists of Chief Executive of the authority called the chairperson. The authority has 15 members as notified by the Government of India. The chairperson's name is Dr. K. Vinod Prabhu, and this authority's objectives are to recognize and protect the rights of the farmers, to encourage the development of new varieties, to stimulate investment for research and development both by public as well as private sectors, to facilitate the growth of the seed industry, to ensure the availability of quality seeds. Who all can apply for the application? According to Section 14 of the Act, an application shall be made by any person claiming to be breeder of the variety or any person being the assignee of the breeder of the variety in respect of the right to make such application or any successor of the breeder of the variety or any farmer or group of farmers claiming to be breeders of the variety or any person authorized in the prescribed manner by a person specified under clauses A to D to make application on his behalf or any university of publicly funded agricultural institution claiming to be the breeder of the variety. What can be registered in this? According to section 14, any variety of such genera and species as specified under subsection 2 of section 29 or which is extant variety or which is a farmer's variety. According to section 15, every new variety will be registered under this act shall be deemed to be novel if the propagating material of such variety has not been sold or otherwise disposed of by or his successor for the purpose of exploitation of such variety in India earlier than 1 year or outside India. in the case of trees or vines earlier than 6 years. Second point, novel if it is clearly distinguishable by at least one essential characteristic from any other variety whose existence is a matter of common knowledge in any country, and uniform if subject to variation that may be expected from the particular features of its propagation. It is sufficiently uniform with essential characteristics, and stable if it is essential characters remain unchanged after repeated propagation or in case of particular cycle of propagation at end of each cycle. What can't be registered? A new variety shall not be registered under this act if the denomination given to such variety it is not capable of identifying such variety or consists solely of figures or is liable to mislead or to cause confusion concerning the characteristics value identity of such variety, or it is not different from every denomination which designates a varieties the same botanical species or of closely related species registered under this act, or is likely to deceive the public or cause confusion in the public regarding the identity of such variety, or is likely to hurt the religious sentiments respectively of any class or section of the citizens of India, or is prohibited for use as a name or emblem for any of the purposes mentioned in section 3 of the Emblems and Names Act 1950, or is comprised of solely or partly of geographical name. Procedure for application. For registration of varieties under section 14, an application must fill these fulfill these conditions. Single and distinct denomination, and affidavit ensuring no use of GU or T, complete passport data of parental line, characteristics of variety with description for NDES criteria, a declaration that the genetic material has been lawfully acquired. An applicant shall disclose use of genetic material conserved by any tribal or rural families. Acceptance and opposition of application. When an application for registration is accepted and it is advertised in prescribed manner, calling objections from persons interested in the matter according to section 21, the grounds of oppositions are that the person opposing the application is entitled to the breeder's right as against the applicant, that the variety is not registerable under this act, or that the grant of certificate of registration may not be in public interest, or that the variety may have adverse effect on the environment. When an application is accepted and no oppositions are raised, corrections are made, and then if register thinks it fit, issue the certificate of the registration of the variety under section 24 of the act. Conclusion. A register called National Register of Plant Variety is kept at the head office of the registry, which names of all registered plant varieties with names and address of their respective breeders and other data are entered. Thank you for your attention.